Good morning. May it please the Court, Mark Gottlieb of Ackerman LLP on behalf of NationStar. I'd like to reserve 5 minutes for rebuttal if that's okay.
Very good.
And before I get started, I just wanted to note one thing. Mr. Stopa has filed this morning a bunch of supplemental authority which appears to be directed to the issue of prevailing party attorney's fees. My understanding from talking to him before we came in is that he intends to devote at least some portion of his argument to the attorney fee, the pending motions on attorney's fees. My intent this morning was to address the substantive merits of the appeal, but obviously if the Court has questions regarding the fee issue, either now or on rebuttal, I'm happy to answer those questions.
Thank you.
The lower court in this case erred in granting Mr. Decoursy's motion for involuntary dismissal at the conclusion of NationStar's case-in-chief at trial, construing all of the evidence and inferences in a light most favorable to NationStar. NationStar made a more than adequate showing of standing at trial, both standing of the original plaintiff, Aurora Loan Services, which Mr. Decoursy conceded, and NationStar standing from the time it substituted in as the party plaintiff through the time of the trial in this matter when the note was surrendered and presented and filed and admitted into evidence at trial. And to the extent that this Court were to conclude that the record and evidence presented at trial was insufficient to establish standing, and the trial court abused its discretion and committed prejudicial reversible error in excluding relative evidence that was probative of standing, specifically assignments of mortgage and a power of attorney under which those assignments of mortgage, or one of those assignments of mortgage, was executed, because those documents demonstrated NationStar's right to possess and control the note, to reclaim it from the court file, which goes to the issue of constructive possession. And that's really the fundamental issue here, is one of constructive possession, and why we think this case is distinguishable from Jawai, and I never know how to quite pronounce that case, and Creedon, and also the Court's decision in Houck, and even the recent decision that was issued in Partridge. In order to establish standing as the holder of a blank endorsed instrument, a plaintiff must demonstrate possession of that instrument at 2 times by this Court's precedent: the time of filing of the foreclosure and at the time of trial. Mr. Decoursy conceded again that Aurora had standing at the time this case was commenced and filed, that it possessed the blank endorsed note. There is no dispute in the record that Aurora placed that note into the court file, and then Aurora requested that it be substituted out as party plaintiff, saying that it had transferred all of its rights to service and enforce this loan to NationStar, and that was granted without objection. So then the question is, for NationStar to establish that it had standing at trial, it had to prove possession. But possession sufficient to establish standing doesn't have to be direct physical possession of an instrument. Florida law has evolved to recognize the concept of constructive possession. Then constructive possession is enough to give somebody holder status. In other words, a plaintiff can be a holder of a note that is located somewhere where that plaintiff has the right to reclaim it and possess it. They have the power to exercise control over that instrument. That concept has been recognized by this Court in its Fan decision. Fan cited to the 3rd DCA case of Decter versus Menendez, which is probably the seminal case on that topic. The 4th DCA has recently expanded upon that in Caraccia, and also in the Raffaelli case that we noted as supplemental authority, a very recent case. And the test that those cases establish for constructive possession is, does the plaintiff have the power to exercise control over that instrument? Do they have the right to reclaim it and deliver it to the court on request? Typical examples where that constructive possession exists and has been found are cases where the note is in possession of a servicing agent, the note is in possession of an attorney, the note is in possession of a contract custodian, which frequently is the way pooling and servicing agreements are set up. You have the trust that owns it, and there's a third-party contract custodian that possesses it. In all of those situations, the real party in interest has the right to reclaim it from the attorney, from the custodian, and as a result of that, they have constructive possession. And that's enough for holder status. There is no reason why that same rationale shouldn't apply to notes that have been placed in a court file. The rules of judicial administration, in particular Rule 2.430H.
Do we know who ordered the note to be produced at trial?
The request to produce it at trial was made by NationStar.
Okay, and the trial court exercised its control over...
The note was delivered and was present at trial at the request of NationStar and was in the witness's hand at trial and introduced into evidence. Again, the rules of judicial administration make it clear that the clerk holds documents, promissory notes that are filed with it, in a custodial capacity. It doesn't own those documents. It holds them on behalf of the parties that place them there, and it returns them in the ordinary course. It happens every day upon request of the party. At a conclusion of a case, upon dismissal in the event of a loan modification, whatever it may be, the clerk acknowledges that there's a custodial capacity in which it holds the notes and returns those to the party that's placed them there and that requests them. As an example of how the arguments that are being made by Mr. Decoursy could lead to extreme results, if Aurora had not transferred servicing rights in this case and had remained the plaintiff throughout and had filed the note as it did in the court file and never took it back and just showed up at trial, we could not credibly argue that Aurora had somehow forfeited its status as a note holder and lost its standing because it took the note and gave it to the clerk and never reclaimed it in advance of trial. At all times, it would have been deemed to have constructively possessed that note because it had the right to reclaim it from the court file, the right to ask the clerk for it and get it back. And that's what constructive possession is. And once NationStar substituted in as the party plaintiff for Aurora, it acquired that same right and power as the party plaintiff to reclaim the documents that had been placed by the plaintiff into the court file. And that gives it constructive possession of the note, and that entitles it to claim holder status as evidence of what transpired at trial, where it requested the presence of the note and handed it to the witness and admitted it.
Why doesn't our case in Partridge, which was the subject of a supplemental authority notice several days ago or a week ago, why does that not control? Because in that case, NationStar's position was the clerk is holding it at our direction. We asked the court to take judicial notice, so the court recognized that we asked it for judicial notice and so forth. And our court said, it's not enough. That's not enough to establish constructive possession.
Well, I don't know that it's entirely clear that all of the constructive possession arguments were advanced on the face of the decision, which I know is not even final yet. But the important distinction in Partridge is that the note had been placed in a court file by a different party in a different case. NationStar was never a party to that case. The note was never placed in the court file in the case in which NationStar was a party. And that is what makes it possible.
NationStar filed a certification stating the note and mortgage are already with the trial court, asked the trial court to take judicial notice of the originals and transfer them to the NationStar foreclosure case. The trial court granted the motion, which suggests that NationStar was exercising the same level of control as it is claiming to have exercised in this case.
Well, I think it is different only in the sense that the note had been filed in a different proceeding. And that seems to be a focal point of the argument.
How is that a distinction when the court granted NationStar's effort to control the note by transferring it into the new foreclosure case and taking judicial notice? I don't understand what your distinction is.
Well, again, the distinction, I understand that it had been transferred over. The distinction is that it had been placed in a court file in a different proceeding and then moved later in the case. But I would...
So it's not the fact of exercising control then that you're saying is determinative?
It's the right to exercise control.
Well, NationStar had the right to exercise control in that case because the court allowed it to exercise control.
I understand. I believe it to be factually distinguishable, but to the extent it's not, then I would urge the court to revisit the issue, and I understand that decision is not yet final and it is subject to rehearing, because as a practical matter, it doesn't serve the purposes of, under the code, of why we even care about possession to begin with. It's creating rigid and artificial requirements that are inconsistent with that.
Counsel, if we're going to talk about practicality, how hard is it for a bank, and I'm not faulting NationStar in this case, but we've seen case after case where there's an assignment of mortgage and there's no assignment of the note. Documents are lost and then they're found and they're filed or not filed. And we've seen, I don't know how many colors of Crayola we can find on the same issue, but we keep finding new colors. And this just seems to be a practicality issue. Why isn't the bank doing it correctly to begin with?
Well, first of all, the law continues to evolve. The idea that a substituted party, for a party that had possession and clearly had standing at when the case was filed, that party, when they substituted, wouldn't acquire that party standing, is something that's evolved in the law over the last several years. The idea that you would have to separately get an assignment of note and mortgage until rulings in Creedon or July, I don't think would have necessarily or naturally occurred to people, because Aurora was the holder of the note. Aurora walked into court and represented to the court and secured relief based on this representation. We have transferred all of our standing to NationStar. They are now the real party in interest with the right to enforce.
That was not an evidentiary proof, was it? That was an argument to the court saying, we're washing our hands, here's the party, please let us out, let them in. I mean, that is not an evidentiary determination of standing.
It's not an evidentiary determination of standing.
It's a substitution of a party.
Substitution of a party, but there are plenty of cases that say...
The Supreme Court has said since, I don't know, the 1800s that you've got to prove standing at the inception and at trial.
And there are also countless cases that say when an original party has standing, an order of substitution conveys that standing to the substituted party, including the 4th DCA very recently in the Raffaelli decision, which is very, very factually similar to this case. In that case, you had what you had here. You had an original plaintiff, a loan servicer, who filed an action as a note holder. They possessed the note on behalf of an owner. They filed the note in the court file. And then they substituted another party plaintiff. And the court, the 4th DCA in that case, said the substituted party acquired the standing of the original servicer that was the holder without any independent proof or requirement and was entitled to enforce the instrument. No separate proof of possession or assignments of mortgage or anything else was required in that case. And again, going back to why we care about proof of possession in the first place, because blank endorsed instruments are bearer paper. And so we're concerned that when they're floating out there in the stream of commerce, we need to know who had them when, because whoever had them had the right to enforce them. None of those concerns are present here. We know where this note was at every material moment. It was in the hands of Aurora, which then said, we've transferred our rights to